welcome to this month's risk management, risk reduction class. We're going to talk about three, what I call hot topics in today's market. So hopefully this class will help you deal with some of the issues that are kind of front and center right now due to the rather hot market we're in. And so with that being said, let's get right started. Lindsay is going to monitor the chat. And if you have questions at the end, I'm hoping to finish in time, a little extra time, maybe to answer any questions about these or any other questions you might have. Let's jump right into today's topic. Three hot topics in today's market. What we're going to talk about is non-refundable deposits. I've talked about that a little bit before. Some of you are familiar with this. I will tell you that if you've used the addendum that I've provided you in the past, I've updated that this week and I've improved that a bit. Talked to another attorney and got a couple of insights into how to make that even a better document to accomplish what we want to accomplish, and that is to get a payment to the seller in exchange for extending escrow. All right, so we'll talk about that. Also going to talk about escalation clauses. I continue to get quite a few questions about that. I want to talk to you a little bit about it from both perspectives. One, if you're writing a clause for your buyer, and two, if you're receiving escalation clauses as a listing agent, some things to think about. And then finally, canceling purchases and escrows. The cancellation, the CC, contract cancellation form, has been changed quite a bit. So I wanted to review that especially with you today, as we are having buyers not perform and sellers moving on to backup offers, and how you do that successfully. All right, so let's jump right into it. First of all, non-refundable deposits. I want to talk a little bit about liquidated damages. Liquidated damages, in the event one party defaults on the contract, liquidated damages define what the other party is entitled to. The other party is entitled to their monetary damages that a default causes. As many of you know, I've shared this with you before, real estate contracts only allow, for the most part, monetary damages or specific performance. In other words, do something you agreed to do, or pay you your monetary loss if you were injured by the other party in a contract. So the injured party, though, in order to collect damages, must prove that the other party defaulted, and they must prove what their monetary damages are. And that can be somewhat problematic in some cases, especially for rather unsophisticated residential sellers. For them to determine exactly what their damages are and to go through the trouble of proving it, going to court with that evidence, maybe having it challenged, can be somewhat problematic. So an agreement can be made between the buyer and the seller that predetermines what the seller's monetary damages are. That's exactly what liquidated damages means. It's a predefinition by mutual agreement between the buyer and the seller as to what your dollar damages are, whether you really have those dollar damages or not. It works both ways. You might not have that large of dollar damages, or you might have larger dollar damages. But, if you have a liquidated damages clause, that's going to specify exactly what your damages are. Now, liquidated damages does not automatically provide that the seller gets to retain the deposit if the transaction doesn't close. It only predetermines the seller's damages. So to retain liquidated damages, the seller must still prove the buyer defaulted. In other words, breached the contract and failed to close. So like I said earlier, to get damages, you have to prove what your damages are and that the other party, in fact, defaulted and damaged you. With liquidated damages, you eliminate having to prove what your damages are. It's been pre-agreed by the buyer and the seller, but you still must prove ultimately if the buyer claims they did not default, then the seller would be obligated to prove that the buyer did in fact default. Now, non-refundable deposits, a little background on non-refundable deposits. Before I do that, I want to say one more thing about liquidated damages. I didn't make a slide for it. I meant to, and I didn't get to it. I want to make a couple points about liquidated damages. Liquidated damages are contained in paragraph 29 of the RPA. And paragraph 29 requires both parties to initial liquidated damages paragraph or an affirmative statement signed by both parties that the liquidated damages clause is a part of the contract. So it's not defaulted into the contract. It has to be actively included in the contract by either initials or an affirmative statement on a counteroffer that the other party accepts. Now, liquidated damages can be for any kind of property. You know, again, predefining what a seller's damages might be. However, for 1 to 4 residential units, one of which the buyer intends to occupy, civil code caps liquidated damages at 3%. So if a buyer put a 5% deposit and it's a single family home or a duplex, anything less than 5 units, 1 to 4, one of which that buyer intended to occupy, even though they put a 5% deposit in escrow, if they were to default, the civil code only allows them 3%. That's pretty well known, and so I'm probably not telling you anything you didn't know. But what is amazing to me sometimes is how many people don't realize the property that is limited to 3% is fairly narrowly defined. 1 to 4 units, one of which the buyer intends to occupy. So a buyer is buying an investment condo, and they put 5% down, 5% deposit with their offer. They default, they could lose the entire 5%. Why? It's an investment property. Someone's buying land and they want to get the attention of the seller, so they make a 10% deposit. They default, they could lose the entire 10%. So only 1 to 4 residential units, one of which the buyer intends to occupy, has that 3% cap. That's most important for those of you representing investors, that they understand if they're making a larger than 3% deposit, that entire deposit, and you sign liquidated damages, that entire deposit is at risk in the event of a default. Okay. And then finally, another thing about the liquidated damages, just to keep in mind in a market like today, courts have held that although you are predefining your damages by liquidated damages, you actually have to be damaged. So courts have held that if a seller, in fact, the buyer defaults, but the seller was not in fact damaged, that the seller would not prevail in retaining that deposit if the buyer took that to court. Now, what does that mean in today's market? So a buyer defaults on a contract today for a $900,000 house, and the seller doesn't care too much that he defaulted. I'm going to keep your deposit, and I'm going to sell the house for $1 million. Guess what? Upon close of that escrow at $1 million, the buyer would likely prevail if they brought an action to get their deposit back, because it would be easy to prove the seller wasn't damaged at all. If anything, the seller benefited by the buyer's deposit, by the buyer's default, excuse me. So keep that in mind. For liquidated damages to ultimately prevail, there has to be real damages. And if it's easy to prove that there wasn't, i.e. you sold the house 2 months later for $100,000 more than I was going to buy it for, I'm going to get my deposit back, even though I defaulted. So keep that in mind. Okay. Now, non-refundable deposits. In general, the civil code, I'm dumbfounded here. This is a wrong slide. There's supposed to be the word not right here. General Civil Code does not permit contracts to impose penalties or forfeitures. Boy, it's pretty embarrassing. I want to say that again because don't believe what your lying eyes are telling you. Civil Code does not permit contracts to impose penalties or forfeitures. That's the jurisdiction of the judiciary, not between private parties. So what does that mean? What that means is agents frequently make one of two common mistakes that are in violation of civil code for the most part. There are narrow exceptions, but for the most part, agents violate civil code when they charge a daily penalty. So buyer doesn't close on time, so the seller sends an addendum over. Okay, the buyer will pay $100 a day penalty until they close. That buyer could easily, and the key word here is easily, after close of escrow, go to court and get every dime of that back. Why? Because penalties are not allowed. Now, per diems are daily expenses. So if you're going to write an addendum that's going to call for a daily payment by the buyer because they're closing escrow late, there's a couple of things you got to keep in mind. One is do not use the word penalty. Use the word per diem. That's perfectly okay. The other thing is per diems must be reasonable to the actual daily cost. So you've got a little 3-bedroom, 2-bath house in Mira Mesa, and the seller wants $500 a day per diem because the buyer is late. You're not going to prevail if that ever went to court. Why? Because that's way in excess of what your actual daily expense was. So when calculating a per diem, it's okay to round up a few dollars. It's $109. You want to make it $125. You probably get away with that. If it's $149, making it $250 will not work. And again, no harm, no foul. If the buyer pays it and doesn't care, then I don't care. But I don't want you to get in trouble with your sellers by writing a clause that a buyer later objects to and prevails because you charged what courts would rule is a penalty, even though you didn't use the word. In other words, per diem is your daily expense. So your daily expense, $107, but you charge $250. Courts are going to say you charged a penalty, whether you called it that or not, and they're going to reverse that and give it all to the buyer, give it all back to the buyer. So avoid penalty, make it reasonable. And then the final thing is every contract, real estate contract, including addendums, if it's time related, must have a termination date. A listing contract that doesn't have an expiration date is invalid. A purchase contract that doesn't have a close of escrow period of time that's either date specific or period of time specific. In other words, 30 days or 45 days or April 15th. It's got to be specific. The law does not allow open-ended real estate contracts. So a common mistake agents make with per diems is they say, buyer shall pay, and they do it right, $112. Wow, that's very right. Daily per diem until escrow closes. Well, that's not going to work technically. Why? Because it doesn't have an end date. So you've got to add an end date. Escrow shall close on or before. In any event, escrow's got to close on or before you give it a month. So the buyer's going to pay a daily rate for a month. And if he doesn't close, the contract has terminated unless you extend it again. So that's the first mistake agents sometimes make. They use the word penalty when they should probably be using the word per diem. And then the point of today's class, non-refundable release of deposit. So I get calls all the time and probably get on average one a week. Somebody's either being subjected to a non-refundable deposit release, or our seller wants to write a non-refundable deposit release. And civil code really doesn't allow that. So, but don't worry, I've got a solution for that. Additionally, by the way, the RPA, paragraph 5A3, states that any clause calling for a non-refundable deposit or forfeiture of the deposit is invalid unless it complies with civil code liquidated damages rules, which are extremely complicated. I've had no less than 2 attorneys who we had on retainer in the past decline to even attempt to write a forfeiture of deposit clause because they just felt like that there's so many different aspects to that relative to our RPA that it's just not a smart thing to do. Okay, so if you can't keep the deposit, or you can't have the deposit, released to you non-refundable, what do you do when a buyer wants to extend and the seller only is willing to extend because the buyer's late? If the seller can get their hands on the buyer's deposit. So how can you handle that? Well, you can sell an option to extend escrow. So what does that mean? All right. So what I'm going to show you now, it's in your handout. It's also on Agent Hub. And again, I updated the addendum itself. I'm going to go through that with you. So first, a little explanation, a little outline, and that on Agent Hub, so that with you, 3 months from now, 6 months from now, you need to access this information. This will remind you of what we've talked about today. Okay, so as I've stated, courts abhor forfeitures and penalties and non-refundable deposits when there are liquidated damages provisions in the contract. You're just going to get in trouble if you use the word forfeit. In fact, I tell agents all the time, never, ever, never, never, never use forfeit, penalty, or non-refundable in any deposit language of any kind. Okay, so courts don't like that. So any language that calls for a non-refundable release of the buyer's initial deposit would likely be unenforceable, and more importantly, when we represent sellers, be voided by a subsequent judicial proceeding. And then our seller is going to be looking at us and wondering, why did you do this? Why did you not, understand that it couldn't be done? So as an alternative to the seller asking for the buyer to release their initial deposit non-refundable, the seller can instead, and this is the key point, sell an option to extend escrow to the buyer. And that buyer can then exercise that option and extend escrow. That is perfectly legal, and option payments are rarely refundable. So rather than having the buyer release some part of his initial deposit non-refundable, the seller instead receives an option payment, and they can receive that option payment immediately. And that will, the seller will then allow the buyer to extend the escrow with the payment option. Over the many years I've been doing this, we've probably done this, maybe not 50 times, but I'd be surprised if it isn't real close to 50. We've done it more than 25 or 30 times, and this very, very successful, what I'm talking about. Okay, so the cost of the option can be applied to the purchase price, which is the usual provision. So the seller, it's similar then to releasing a deposit, except they're not releasing a deposit, they're buying an option. Or it can be applied in part, which is more rare. Sometimes the seller is actually incurring some real expense by extending the escrow. So the seller will say, well, if the buyer will cover that expense, then I'm willing to do it. So you would make some portion of the option not applicable to the purchase price, so that the seller would be getting that additional funds to pay the expenses that the seller incurred because they extended escrow. So that's sometimes done. You'll see how that's done in a minute. If ultimately the buyer does not close escrow through no fault of the seller, the option payment is not refunded to the buyer. And that's pretty typical in contract law. Option payments are usually, not refunded. The buyer got the benefit of the bargain. They got the right to extend escrow. And so they got what they paid for. So there's no judicial reasoning to force a seller to return an option payment to a buyer who ultimately doesn't close. So it will unlikely be, it will not be overturned in a judicial proceeding in all probability. Okay. So now what follows is a simple option agreement to extend escrow. And when you see it and when you get it from Agent Hub, Lindsay put it on an Agent Hub in a way that you can download it and then edit it, so that you don't edit anything in black without checking with me, but edit the stuff in red, and you'll see that in a moment. Okay. Now, some important points about the initial deposit being held in escrow. If the buyer and the seller agree, the buyer may use the money held in escrow to purchase the option. And that's the common way this is approached. In such a case, the deposit would be reduced by the amount of the option payment. It's important that escrow does not state in an escrow amendment that the deposit is being released to the seller. The deposit is not being released. The buyer and the seller are agreeing to reduce the deposit, and the buyer is authorizing escrow to use that money then to pay for the option. See, so that's what they're agreeing to do. They're using the money being held by escrow to pay for the option. That's a very fine nuance. I can tell you Barb gets it. Why? She's smart. I don't want to take anything away from her, but she's also done this multiple times for me. I've had some escrow officers really struggle with this. What kind of makes me smile as I tell you this, I know one escrow officer, I won't name her. Some of you might know this person. They understand it, or at least they write it up correctly in their escrow instructions, but actually they don't understand it because then they don't follow it correctly, which is, sort of, okay, I'll write what you want us to write, Walt, but I'm not sure what I'm doing here. That's kind of what happened in at least one case recently. All right. So the funds that are released are equal to the option payment. But the point that's important is the funds are released, not the deposit. That is so important. Okay. Now, just jump ahead a little bit. When you write this addendum up and the buyer and the seller agree to it, and then escrow generates an escrow amendment to accomplish this, I highly recommend that you send it to me and let me review it just to make sure they don't inadvertently suggest that the deposit is being released non-refundable, because that's this whole exercise is to avoid that. All right. Now, if the seller is unwilling to let the initial deposit be reduced, then the buyer is going to have to make a payment directly to the seller or through escrow. That's not very common. It's happened a couple of times. If that's the case, let me know, and I'll help you with it. But the argument here is what you're trying to do is come up with a way to get the deposit to the seller in a way that's sort of, judicially acceptable. And you're not really trying to get the buyer to come up with more money. You're just trying to get your hands on that deposit. You're extending escrow, and you're recognizing that if the buyer doesn't close, you still can't get that deposit because the buyer might not sign a release. So before I extend escrow, I want that buyer's money in my hands. That's what the seller is saying. So that's why usually you're just using a portion of the deposit to pay for the option. Okay. Now, in the event the deposit funds are being used to pay for the option, again, that's the more common, the escrow instruction should make the next two statements in one way or another. The buyer and the seller agree the buyer may use the funds being held in escrow to pay for the option and authorize escrow to immediately release the funds. See, not the deposit. Immediately release the funds equal to the option payment to the seller. That's so critical. And then the buyer and the seller agree and acknowledge that the initial deposit is being reduced by the amount equal to the option payment. All right. So what does the option agreement look like? You have it in your handout. I'll just walk you through it real quickly. It's pretty straightforward. What's in red, you're going to replace. Seller agrees to sell to the buyer an option to extend the scheduled close of escrow date from, and then you put in whatever the current agreed to date is. Now, that could have been amended. That could be a new date because you had an ETA earlier and now they want to extend again. And the seller is saying, well, I need to get my hands on that deposit money. Okay, so whatever the currently agreed to date is, you plug that in and then you plug in the new closing date. And that's called the extension of time escrow option. That's what this is. The buyer will pay X amount of dollars to the seller for this extension of time to close escrow option. Said payment is solely for the option to extend time to the buyer to close escrow and shall not be refunded to the buyer should the buyer fail to timely close escrow through no fault of the seller. Okay. In the event the transaction does not close on or before the new closing date, plug that in. Does close. I misread that. In the event escrow does close, then you have three options here. All of the money, in other words, if they're paying $10,000 for the option, then $10,000 will be credited to the sale price. If the seller is retaining $4,000 because they're incurring some additional expense, then $6,000 of a $10,000 option payment, $6,000 would be credited to the sale price. If the seller very rarely, does not want any of the option payment to be credited to the purchase price, then none. So you're going to, figure that out and then plug that in there. All other terms and conditions of the sale remain unchanged. Time is of the essence. There will be no further extension to the closing date. Now, this is in there at the advice of the attorneys because they want it to be very clear that the buyer wasn't induced to buy the option because he was maybe verbally promised, look, if you need more time, I'll give you more time. See, so that's why that's there. Now, that does not mean a buyer and a seller cannot extend that escrow, but you need to tell the buyer in this agreement there will be no further extension, so you can memorialize the fact that you didn't, induce the buyer to pay this option by promising him he had some kind of unlimited right to get his ducks in a row and close the escrow. So that's a pretty important clause, even though you can certainly amend that with a future agreement. All right. Buyer and seller agree that the buyer may use the buyer's funds now being held in escrow to pay for this extension of time addendum. In such event, the buyer's deposit will be reduced by a like amount. So you're memorializing that. By signing this addendum, the buyer, one, simultaneously agrees to purchase and elects to exercise this extension of time to close escrow option, shall immediately authorize escrow to immediately release to the seller. And that's important. I've had a couple of times where the agents went to all this trouble. We explained it to the buyer's agent and the buyer's agent got it. They understood it. Everybody was okay with it, but the escrow never released the money. I got to tell you, this is a little bit sophisticated for a lot of escrows. It's just not the kind of thing they come across. So escrow actually told me one time, well, I can't release that money. It hasn't closed. And I had to go walk them through the agreement, Oh, okay. So, that's why, you want to make sure your seller gets the funds. That's the whole purpose of doing this. So you immediately release to the seller the money from the buyer's funds now being held in escrow to pay for the option. And of course, the buyer agrees to all other terms in this addendum. This offer to sell extension of time to close escrow shall expire. This is usually a fairly short fuse. You don't want, you want the buyer to either, put some skin in the game if they're going to extend, or let's cancel, let's move on. So, I've often seen this, by the end of the day, if we're doing it in the morning, certainly by middle of the afternoon the next day, maybe 24 hours out. So this is a fairly short time. This should be explained to the buyer before you deliver this to the buyer. The buyer should the buyer's agent. The buyer's agent should sort of have an idea of what we're talking about here. If they have to read this, having never had a discussion about this, it's going to be a challenge. I've often volunteered and have done this for agents. I've talked to the other side to explain to them exactly what we're doing here. The buyer shall remove all contingencies and attach CR as part of this exercise of this extension of time option. Failure to remove all contingents at this time shall make this addendum null and void. All right. So that is the option to extend escrow addendum. Now let's talk a little bit about escalation clauses. Couple of things to think about. Paying over list price. Well, there's an appraisal contingency. So usually if there is an escalation clause, it usually results in a payment well over what the comps probably support and what the appraisal will come in at. So there's two ways to deal with the appraisal contingency. One is simply remove it. That's one thing. You can require the buyer to remove the appraisal contingency, or as a buyer, you can remove it. Or two, lower the appraisal contingency threshold. I'll pay, an escalation clause of $10,000 better than the best offer, but it's got to appraise at least and then some numbers so you can lower the appraisal contingency. So how do you do that? Well, removing the appraisal contingency with the offer is pretty simple. You simply check the box, no appraisal contingency. Lowering the appraisal contingency threshold with the offer, you check this box and then plug in the price, the minimum price you want it to appraise for in this blank here. Okay. There's one other factor to keep in mind, and that is an amendatory clause. If the buyer is getting an FHA or VA loan, and they are at the same time agreeing to pay over appraisal, as most of you know, the amendatory clause makes any waiver of the appraisal null and void. And the mandatory clause supersedes anything else signed by the buyer. So if the transaction is an FHA or VA loan, then the mandatory clause is automatically attached to the agreement. And the mandatory clause contains very specific language. It expressly agreed, notwithstanding any other provision. So it doesn't matter anything else that the buyer signed. The purchaser shall not be obligated to complete the purchase of the property or to incur a penalty or a forfeiture of the earnest money deposits unless the purchaser is given a written statement setting forth the appraisal value of the property at not less than the purchase price. Civil code requires that the purchase price be on this blank. You can't adjust that. So whatever the buyer agreed to pay for this property, it must appraise for that if he's getting an FHA or VA loan. And if it doesn't, it doesn't have to appraise for that. It must appraise for that in order to enforce a waiver of the appraisal contingency. So you just really can't remove it. And if it doesn't appraise, even if you sign an appraisal contingency removal, it has no standing. Now, the buyer can purchase the property in excess of the appraisal without regard to the appraisal if they choose to. Okay, now, the escalation clause addendum. Let me walk you through that real quickly. It's in your handout, and I'm going to give this to I don't think this is an agent hub yet. I want to write a little bit of an explanation about some of the things to keep in mind, and then we'll put this in Agent Hub as well. So this is almost exactly what you should write if you are going to create an escalation clause. And by the way, I should say this now, and I'm going to say it again, and you should say to your client, we don't necessarily recommend escalation clauses, but they're perfectly legal and you're certainly allowed to do them, but there's a lot of risk involved in it. So you should be somewhat aware of it. This clause that I'm going to walk you through handles the risk pretty well as far as being tricked into paying more by some sort of sleight of hand, but it does not prevent a buyer from paying way too much for a house. So the market market advisory is I put that in your handout. You should review that with your client in any time that they're paying more than the list price. And even when they're paying list price, you should review that with them. But it's especially important when they're paying extra for a property. Okay, so the addendum should state what the price is. You've got to have a base price. Sometimes I see escalation clauses, I see contracts with escalation clauses, and there's no base price. That could be very problematic. So, there's a base price, and then it's further modified by this clause. In the event that seller receives another offer to purchase the property, which results in net proceeds, that's a key word, net proceeds of the sale payable to the seller equal to or greater than the net proceeds of this particular offer paid to the seller, then the purchase price stated in this offer will be increased by an amount that generates a net proceeds of sale equal to X amount of dollars. Now, where this is very poorly written is, I see this all the time, and again, if you're the seller, I'm not as concerned about it if the buyer is writing this, but the buyer will write silly things like, buyer will pay $5,000 higher than any other offer seller receives. Okay, well, the seller received an offer for $750,000, so the buyer who wrote this clause is going to pay $755,000, but didn't realize that the $750,000 offer called for a $10,000 credit to the buyer for closing costs, is what it really would be for. So the net proceeds is pretty important, especially when you represent the buyer. The competing offer must be a bona fide arm's length. Believe it or not, there are situations where to force a buyer to pay more money, sellers and listing agents have got neighbors and relatives to write offers that aren't even legit. It has to be written on a car form, have substantially containing all the material terms so you can see what other concessions might be in the offer, and does not include seller financing. Yeah, I'll pay you a lot of money if you loan me the money and only charge me a 2% interest rate. Well, that, and provides for closing within 60 days. Yeah, we'll pay a lot of money, but not for another year. Well, I don't want that offer to force my buyer to pay more money, and is not contingent upon a competing offer's buyer's property selling. That's still sort of wishful thinking. I'll buy your house, but only if mine goes into escrow, and I'll pay a whole lot more for your house because I'm selling my house for a whole lot more than it's worth. Well, that's never going to happen. So that offer that is forcing your client's offer to be increased is not a legitimate offer, I would argue. Net proceeds is defined here. It's the amount payable to the seller after all price adjustments, credits, and concessions are deducted. Documentation. In the event the competing offer causes an escalation, then the seller is to provide a copy of the competing offer to justify that increase. Now, in the event the purchase price is increased pursuant to the escalation clause, then the increased purchase price shall be stated in the seller counter offer, and that's generated by the seller, and then upon acceptance by the buyer, that becomes the new price. Now, this is the protection for your buyer, because this clause actually gives the buyer a second bite of the apple. So some idiot comes in and pays $50,000 more than, what the house is even remotely, any other offer, even remotely close. And now you got to bump your price by $50,000. Now I'm not going up that much. Well, you'll end up not having to go up that much because if you don't sign the counter offer. So this is a very important clause right here. And then termination. This is another thing that, believe it or not, this has actually happened. Halfway through escrow, a backup offer comes in, more money than you're in escrow at, and the seller gives notice to the buyer, you got to increase your offer. Well, what do you mean? Well, we're in contract. Yeah, but I got a higher offer. Yeah, but we're halfway through escrow. So this escalation clause terminates once this new price is established at the time that these offers are being received and you're entering into the offer on the first go round, if that makes sense. And then the cap, purchase price triggered by this escalation clause should not exceed, and then some dollar amount as a cap. Now, here's what's interesting about the cap. It's recommended, if you have the buyer, not to put a cap in, because what does that do? That simply tells the seller what you will pay for the house. So if the documenting the increase in purchase price, paragraph 6, is included as it's written, you don't need a cap. Because if some number way beyond what the buyer was willing to pay comes up, the buyer simply doesn't sign that seller counteroffer. Now, what do you do when you get an escalation clause with an addendum? Here's what Carr, and both of the attorneys I consulted with to write this suggested. We all agreed. Don't accept the escalation clause, just counter the sale price at the cap. Whatever they said their cap is, that's sort of like them saying, I'm going to pay $750 for your house, but I would pay as much as $850. Okay, then I'm going to sell it to you for $850. You don't even need competing offers. So if you're writing an escalation clause, my recommendation is leave the cap out. Some buyers are a little nervous. They don't quite understand the sophistication of paragraph 6. So if they're not comfortable without a cap on it, put it in, but you do run the risk of getting a counteroffer at that cap, because I'm not the only person that figured that out. Okay. Hope that explains escalation clauses a little better and gives you something to work with. Now let's talk about canceling purchase contracts and escrows. And I'm going to go through this fairly quickly. I want to get to the last couple of documents. That's the ones that are maybe a little newer to you. So, reasons that a party may cancel by mutual consent. Both parties can agree, okay, we're not going to go forward with this transaction. By exercising a contingency right. So buyers have contingency rights. They can cancel if a contingency is not met. They have a whole lot more contingencies in the boilerplate than sellers do, but sellers have some contingency rights, especially the ones that they create, like contingent on seller, identifying and closing escrow on a replacement property. That would be a seller contingency right. And then pursuant to the other party's failure to remove a contingency or to perform a contractual action or finally close escrow. So those are the grounds of why you will cancel. And I'm not telling you anything you don't already know. Yeah, to cancel a purchase contract for non-performance by the other party, it's very important. You must first give notice to the other party. Either give the notice to the buyer to perform, either remove those contingencies or take that contractual action. Or if you have the buyer, before you can cancel, pursuant to a seller not removing a contingency or not performing, you would have to give the notice of a seller to perform. Or if you want to cancel because the other side's not closing, you have to give a demand to close escrow first. Here's a common mistake. Do not do this. Courts have a problem with this. You do not have the right to cancel until after the notice is given and the time period for the notice has elapsed. So do not provide a notice to perform and a cancellation of the contract at the same time. The contract doesn't give you the right to do that, and it could be argued that you were acting in bad faith. So separate those two actions. I was reading or listening to quite a few seminars and read quite a bit about this over the last many years. And, something that struck me was one of the causes of agents to incorrectly cancel contracts is they're impatient. And I thought that was kind of interesting because that's kind of exactly correct. You're impatient. You want to cancel. The buyer's goofing around. So we're just going to cancel. No, you got to give them a notice to perform first. Okay, I give him a notice to perform, but I want to get this done. I'm going to cancel tomorrow. Well, no, he's got 2 days on the notice to perform. So being impatient when you are intending to cancel can cause you a problem. So keep that in mind. Okay, I'm not going to spend a lot of time on this. In fact, I'm going to zoom through it. The notice of buyer to perform has been extended and enlarged quite a bit, but it's very, very straightforward, very simple. Everything's itemized. You check the appropriate box, removing contingencies or taking a contractual action. And then they have 2 days And the contract doesn't really allow you to modify those 2 days. The old RPA, we used to teach buyers to plug in 3 or 4 days sometimes, but that's not available to us in the new contract. Carr told me, and maybe it's my fault, they had too many complaints from agents, maybe all from San Diego County, from listing agents, not realizing that the 2 days was changed to 3. So the forms committee elected to take it out of the RPA. And that's exactly why I thought it was kind of neat that we could slip in a 3 there and sometimes even a 4. But I guess people complained to Carr about it, and they, shame on the listing agents for not seeing that. Okay, notice seller to perform. It's a little simpler. There are less things to be concerned with. There are more contractual actions and less contingencies in the boilerplate. So, and this is pretty straightforward. And again, seller has 2 days to perform. You cannot make it less than, no less than 2 days. By the way, the contract says, and I covered this before, you may remember, if a notice is given incorrectly or contains incorrect information, for example, somebody checks a box here and puts the 1 there, well, then that notice is deemed invalid and you have to start all over again. The buyer does not have to, figure out that what you meant. So if notice is incorrect, the notice has not been delivered. And likewise, if you're giving a notice, make sure you do it correctly. Otherwise, your notice has not been delivered. Okay, demand to close escrow. That's also fairly straightforward. Either the seller demands that the buyer close escrow. Now, 3 days is the minimum time for a demand to close escrow because civil appellate courts, have ruled that, the law says you must give a reasonable notice to a buyer before canceling. And reasonable notice has been deemed to be a minimum of 3 days. And so that's why it says 3 days. Now, do not use a notice of buyer to perform or a notice of seller to perform to compel a closing, because number one, that's a 2-day notice, so that's not correct. And number two, the notices call for the deposits to be refunded to the buyer, both the notice of buyer to perform and notice of seller to perform. If they don't perform, the seller may cancel and must return the deposit to the buyer. That's written that way to, I don't want to get in the weeds there, but to eliminate a challenge to the notices. The courts are somewhat sympathetic to a buyer who claims that it was an extortion. And so you can't have extortion if you don't get the money. So it's a kind of a sophisticated argument. It was interesting. I had a discussion with one of the car attorneys on why that it's in the boilerplate of the notices to perform that the deposit must be returned to the buyer. And again, like I said, it was to prevent those notices from being defeated in court. Not true, not so with the demand to close escrow. You perfectly within your right to keep a deposit if they don't close on time, if all their contingencies were removed and you gave them notice and they still didn't close. You could keep the deposit if you elected to. And you could claim the deposit. You may not get to keep it, but you would be entitled to it quite possibly. So in the demand to close escrow, there's no provision that the deposit will be returned to the buyer. And likewise, the buyer demands the seller to close within 3 days or by such and such a date, which is at least 3 days out. All right, pretty straightforward. Let's look at the cancellation of contract. All right, so that's been modified slightly. Cancel the agreement by buyer or seller or by both. This paragraph 1 cancels the contract depending on what box you check. It can either be, the buyer's going to cancel, the seller's going to cancel, or both cancel. I believe a cancellation of contract should reflect real world circumstances. I have a problem with buyers who cancel, seller doesn't want them to cancel, and they check both buyer and seller canceled this agreement. No, the seller didn't cancel, the buyer did. The buyer may have the right to cancel, and the seller's not happy about it, but the buyer may have that right. So the buyer, you should check the buyer box, not the both box, unless both said, yeah, let's just cancel this. It was a mutual agreement. Now, these terms in the cancellation apply regardless of whether or not the parties come to an agreement in paragraph 2, which is the cancellation of escrow. Paragraph 1 is cancellation of contract. Paragraph 2 is the return of the deposit, or disposition of deposit, probably a better word because the seller might keep it, and the canceling of escrow. Now, why is that in there, and what's the point of that? Here's the point. Canceling a contract is a unilateral act. Buyers and sellers have the right to unilaterally cancel the contract, not an unlimited right. I mean, well, they do have pretty much an unlimited right, but they might be liable to damages. So if the buyer cancels for no good reason, just doesn't want to buy the house, it is rare that the courts are going to enforce a specific performance against the buyer. In fact, it's almost impossible. Why? Because often there's a third party involved, and that's a lender. And, the lender didn't enter into this contract. So what are you going to say? The lender has to make a loan to this buyer? The buyer could be liable for damages, probably not a specific performance, although it is possible, pretty rare, if they canceled without the right to cancel, but they can unilaterally cancel. Either party can cancel. The question is whether they owe damages for that or not. Now, you don't need the other party to agree to a cancellation, and sometimes it's perfectly obvious. The buyer can't get his loan, and he has a loan contingency, so he's going to cancel. The seller says, what? Nope, sorry, you can't cancel. You're going to have to find a loan somewhere. Find somebody who can loan you the money. No. So that's why cancellations are unilateral. They can be unilateral. They're not always, but they usually are. One side or the other cancels. The disposition of the deposit and the cancellation of escrow is bilateral. Both parties have to agree. Or if they don't agree, a judicial authority, either the court or an arbitrator, has to step in. So cancellation of escrow is bilateral, cancellation contract unilateral. Okay, so either the buyer or the seller or both agree to cancel this, elect rather to cancel this contract. And as permitted by the good faith exercise of paragraphs, and then here's a point. Write the contract clause that allows for cancellation, not the reason. Pursuant to paragraph 8, Paragraph 8 is where all your contingencies are explained. So pursuant to paragraph 8, the buyer is canceling, not, gee, the house smells bad. This is direct from Carr. Again, I agree. You get into a lot of debate and argument when you give reasons. Just give the contract clause that gives you the right to cancel. Okay. Buyers fail to remove contingencies after being given a notice. That's one reason they can cancel. The seller has failed to remove contingencies after being given notice. The other party has failed to close after being given notice, or by mutual agreement. Okay. Or other. You can write something in there. Now, release of deposit and cancellation of escrow, that is bilateral, and this has been changed a bit from the old form. So the purpose of paragraph 2, this is to instruct escrow holder to cancel the escrow and what to do with the deposit. This cancellation does not affect the cancellation in paragraph 1. Again, as I said, that's a unilateral action. But, so even though both parties don't agree to this section, paragraph 1 doesn't require the other party to agree to the cancellation. So release of the funds are not automatic. It takes a signed release instructions from both buyer and seller, a judicial decision, or an arbitration award. Now, this comes up all the time. A party may be subject to a civil penalty of $1,000 for refusing to sign a cancellation. That's only true if there's no good faith dispute. that exists between the parties as to who's entitled to deposit. So a seller could believe they're entitled to deposit. And as long as they genuinely believe that, even though they're dead wrong, they will not be subjected to $1,000 fine. You know, the buyer may be obligated to give up the deposit to the buyer. But even though they're dead wrong, the buyer will not be subjected to $1,000 fine. I can tell you, I have never heard of this $1,000 fine ever being assessed. Why? Because, you know, nobody says, I'm just going to jerk you around. You have every right to your deposit, but I'm not signing it. See how you like that. You know, you're not going to find that email. If you do, well, then you might get fined $1,000 if you don't sign. But absent that email, the buyer or the seller will make a claim that they acted in good faith. Okay, this second part of the cancellation, the escrow portion, is a full release. The buyer and the seller cancel the escrow number with the escrow company, and they release each other from any obligation to buy, sell, or exchange the property under the agreement, and they release each other from any and all other claims, and the seller authorizes the release of the buyer's deposit back to the buyer, or buyer authorizes the release of deposit to the seller. So that can be done either way. Now, pursuant to a liquidated damages clause, that buyer's authorization to release deposit to the seller is limited to no more than 3% of the purchase price. And again, that's if it's 1 to 4 residential units and the buyer intended to occupy one of the units. Now, the buyer authorized release of some portion of the deposit. So you can release a portion of it and then the balance returned to the buyer. That's been added to this, and that's kind of nice because it sort of makes it memorializes, you know, look, you know, let me keep $5,000 and you can have $5,000 and everybody will be happy. Okay. Partial release and reservation of rights. Buyer and seller cancels the escrow number with the escrow company. They release each other from any claims relative to selling the property, but no other release is granted. And the escrow will hold the deposit until receiving subsequent mutual instructions. In other words, the buyer and the seller, if D, you know, is applied, you know, and you check here, buyer and the seller agree that they'll decide what to do with the deposit later, or the escrow will get a judicial decision or an arbitration award. All right. Scope of buyer's duty, broker's duty, rather. Agents are not qualified to opine about whether or not a seller is entitled to a deposit or is going to get a deposit, or the buyer is going to get the deposit back. Okay, backup offer addendum. If you have a transaction that does not fully cancel and you resell the property, make sure you include a backup offer addendum as part of that second offer. And the backup offer addendum, it states that the agreement, you know, the backup offer, position number and give it a number, especially if you're a buyer, you want a number there, because as a buyer, having a seller accept your backup offer puts you in line. And if they get a better backup offer and that one's backup offer number 2, well, number 1 gets to go first. And so, you know, it's very important from a buyer's perspective to have that number. All right. And now, the sale is contingent upon the written cancellation of any prior contract and escrow. Cancellation rights for the buyer can cancel the agreement at any time before the seller provides the buyer a cancellation. So backup addendums, backup offers are very buyer friendly because they lock up the property. The seller does not have that same right. If the seller is unable to provide a written signed cancellation, and releases to the buyer of the previous escrow by such and such a date, then either party may cancel. So the seller can reserve a right to cancel, but a time frame is going to have to lapse. So sellers are locked in the backup offers to some degree. Buyers are not. Buyer's deposit, the boilerplate is 3 days after you get a cancellation of the prior contract, or if you check, handled per the agreement, which is in 3 business days of the agreement being created. Time periods in the agreement, the boilerplate says begin again when you get signed cancellation on the prior escrow, or if checked at the times of the agreement. So the 17-day window would start immediately, even though you haven't canceled the prior contract completely, if this box were checked. Now, if the close of escrow is a specific calendar date, that date shall not be extended unless in writing by the buyer or seller. So the contract has a close of escrow date that starts immediately. So if you write a 45-day escrow, that 45 days doesn't start when you get, a 45-day purchase contract on your backup offer. That doesn't start when you get cancellation of the first offer. It starts immediately. The 45 days starts clicking immediately. So that's important to keep in mind. You can extend that in writing if it's taking a while to get that first offer completely canceled. The scope of the broker duty, we don't have any ability to give a legal opinion on the validity of the prior transaction, whether or not it's canceled correctly or not. We're not legal experts in that regard. And then expiration, this offer has an expiration date as well. It's signed by both parties. And then the bottom of the form is a notice of cancellation and release of prior transaction. This is the notice of cancellation of the first offer. And so you can provide this to the buyer when you have the first offer canceled, and that makes this agreement now fully in effect. Hope that was pretty straightforward, everybody. Lindsay, do we have any questions?
Yes, we have a few. Vicky Varnals wants to know, other than the possibility of a new CD needing to be created and signed, which can cause further delays, is there ever any issues with a lender seeing this option?
I've never encountered one. So I guess the short answer is no. I would not I couldn't imagine why a lender would have that problem. It's the buyer's buying the right to extend escrow.
With the proof of the CAR form, should we also request proof of funds and pre-approval? Maybe Dennis can elaborate.
That's for the escalation clause. We want to see the CAR form, but we also want to see that they have proof of funds and pre-approval. It's not zeroed down and not approved and the offer.
Dennis is exactly right. And thank you for asking that question, Dennis. If I understood you right, I think what you brought up is something I failed to bring up, which I should have, and that is anytime a buyer is paying a lot of extra money, you got to make sure the buyer's got that money. If they're paying over appraisal, they're putting down 10%, but they'll pay $100,000 over appraisal. Well, do they have $100,000? Because the lender's only going to loan them 90% of the appraisal. So Dennis brings up an excellent point, and that is, along with the escalation clause or any purchase agreement that in some way, causes a buyer to need to pay extra money, they got to have that money because the lender's not going to give it to them. So yeah, you need proof of funds. That's excellent. Thank you, Dennis.
Dennis,
along with that proof of funds, I've got a listing now, since the increase in the interest rates has gone up so much, I'm checking with the lender to make sure that their pre-approval from a month ago at 3% will still entitle them to buy the property at a 4% loan.
Good point. Yeah. If you don't have a very current pre-approval, you're going to want to talk to the lender and have them update that. Excellent point. Thank you.
For your buyers and your sellers.
Both. Yeah. Right. Yeah.
Dennis, was that the second question in the chat that you wrote? Oh, do you want to go ahead and ask that question, or do you want me to?
Well, if we're doing a cancellation of contract because the buyer couldn't get a loan, what if the contract didn't have the interest rates or the points marked in the contract? So yeah, maybe they only wanted to pay 4%, but they get a loan at 6%. Could the seller enforce that?
That's a good question, and that's why buyer's agents especially should put numbers in there, because a seller could attempt to enforce it. As a practical matter, and this question has come up more than a few times in conversations I've had with attorneys, including several attorneys at Carr Legal. And as a practical matter, the attorneys think that it would be difficult to prevail in the end, especially if there was a substantial rate increase. And I asked, okay, what's substantial? And then they laughed and they said, well, I guess up to a judge. So it would be hard for a seller to say, hey, you agreed to borrow money no matter what the interest rate was because you left it blank. But the right thing to do is to put a number in there for sure.
Thank you, Walt. Great presentation as usual.
So Andrew Mirabelli asks, in addition to proof of funds, what about the bank wanting to know the source or seasoning of funds above original asking price?
Well, that's always going to be the proof of funds. That's always going to be an issue with all funds. So, I mean, you're thinking when you ask that question. So, they got proof of funds. Those funds ultimately have to be verifiable as far as seasoned and not a gift money, unless it's the loan allows for a gift money. Not, came up with an interesting situation, and actually it was kind of difficult. We had a buyer who has a business related to marijuana, perfectly legal, but banks won't take his money. So we've had to be a little bit creative to figure out how to do things like that. So yeah, you always have to keep that in mind, but that's true just in general, always. Yeah.
And now Dennis has another question about the affiliated business agreement.
Okay. Go.
Walt, should we have that with every contract, since we have our own escrow and lender, or is that only where we're going to be using our own lender or escrow?
Isn't it interesting? Because I'm talking to Carr Legal about some very specific issues relative to affiliated businesses, and I don't want to go in the weeds there yet because I'm not done with the conversations with them. But I made this comment and they said that's excellent. And I sounded proud of myself. So what the comment I made is I require personally, I would like to see an affiliated business statement included in every transaction. Now, I almost hate to say this out loud, but I want to be honest with you folks. If you are not using RE/MAX Connections escrow or the lender, then you're not breaking any laws. You're not creating any problems. But the concern is you didn't intend to, but you ended up using them, or you use them so rarely that when you did use them, you forgot all about it because your habit was not to include it. So the official answer is, yeah, we want it on every transaction. If you did not use those services, you're not going to get busted by the federal government. By the way, we have been busted, not Connections, but United years ago. We got into a little bit of a pickle because the affiliated business form was given at the end of the transaction. The law says before you engage the services. And so they use our escrow company, and our agent provided that at the end of the transaction. And unfortunately, the agents got into a fight during the escrow. And as a revenge, they reported us, and we had a little bit of a problem with that. So I'm rambling a bit. Dennis, I appreciate the question. I would like to encourage agents to make that a part of your normal procedure. Just provide it every time.
Those are all the questions that are in the chat, Walt.
All right. Well, if that's it, nobody has any other questions. Thanks for joining me today. Have a great, great day. Hope I answered your questions today. And if you have any others, don't hesitate to give me a call or send me an email. Take care.